Thank you very much, Paolo, for this brilliant paper, really. You have clarified the relational character of family rights, and you have distinguished human rights from other kinds of rights within the complex of the rights of citizenship. The relational rights are not the civil rights, the liberal civil rights of the 18th century. They are not the political rights. They are not the socio-economic welfare rights. They are human rights. For instance, the right of the child to be raised in a family, not on the streets or in an institution. This is a right to a relationship, okay? So going this way, I'm wondering whether we could speak, and I know that this notion is very provocative, of citizenship of the family. We know that in modernity, citizenship is basically individual. Is the individual as a citizen that has the complex of the citizenship rights. But if we talk about the family as a social subject, now in this social subjectivity, there could be inherent a principle of citizenship. There is a complex of additional rights in respect to the individual rights. The family has rights as a family, not as a sum of individual rights, okay? So if we go along this line, we find also the rationale for this reason, because the family performs the role of mediation, a multiple role of mediation for the individual, particularly for children, in respect to society. So these rights refer precisely to the mediation role that the family has to perform. Think of the fiscal system, for instance. You mentioned the tax system as the first system to which we can refer the social subjectivity of the family as a citizenship right of the family. I don't know, it's a little bit provocative, but anyway, I want to know your opinion. Thank you.
Thank you, Pier Paolo. Yeah, well, I agree entirely. I mean, I think, for instance, already one of the most ancient bases for citizenship in the law, the jus sanguinis, implies to some extent a relationality to it. But more importantly in a pluralistic society characterized by mass migration and pluralism, many of the other individual court cases that I didn't have time to treat in this paper, but that do also represent examples, I think, of relationality. And in particular in European countries, in Germany and Portugal and Spain, you find such decisions relate exactly to citizenship. And they relate to the rights to claim citizenship or claim a status of remaining and belonging to the community and having rights within the community as a result of the family relations that have to be respected. This in part has emerged from the European Court of Human Rights jurisprudence applied at a constitutional level, which is a delicious paradox since the European Court is largely responsible for the individualization of rights rather than their interpretation in a relational key. But that's a long way of saying I agree that I think there's an important scope for rethinking citizenship as relationality and belonging to the larger community of the common, for which the common good is relevant in this way.
Unfortunately, we must be very short because we have only 4 minutes left when Gregory Reichberg has to speak at 1:35. So I have Archbishop Minarat, Bishop Marcelo Sanchez, Mr. Bassi, and Jeffrey Zack. I would suggest that everyone speaks for less than a minute and that you answer all the 4.
Is there any constitution which changed its definition of marriage in the last years? Because some constitutions say marriage between man and woman, some say nothing at all. Do some constitutions change the definition?
I want to, I am more or less the same question of Pierre Paolo. What can we do to convert the family as a subject, with rights and responsibility? I don't know a citizen, but it's a subject, a moral subject, like an individual. This is what, but the real question is, what are the constitutions to have recognize the idea of the sacrament, like the Italian constitution that recognizes in some cases that the union of the sacrament is also valid as marriage. So I think it's only in Italy, or there are other cases, because this is very important to put together the marriage with the sacrament. So thank you.
So thank you very much indeed. We know that I appreciate very much your paper, but the sentence, I like it very much as a president of European Family Federation, is when you say those duties rooted in a recognition of the family as a relation reality rather than in the interest of the state. Because the strongest opposition that the government, the movements, the civil society normally does to our association is that you are fascist because you are promoting demographic natalist policy. But my answer is always, this is not the interest of the state, this is the interest of the families, because there are many statistics which show that there is still the desire of having children. So I think that this is a very important point, because one thing is to incentive the families, one thing is award the family.
Yes, I just wanted to add, Paolo, you may have treated it in the paper, I don't know, but it's worth also referring to the Universal Declaration of Human Rights, because this is the closest we get to a global charter, and it is an extremely important one. And family is mentioned 7 times in the Universal Declaration of Human Rights in various contexts, but one of the key ones is in Article 16. It says the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. So this is an extremely important point, because this is really the central constitutional charter for the world if we refer to it and uphold it. So I wanted to emphasize that point.
Thank you very much for such wonderful questions, and I'll be very brief in trying to answer them. So with regard to the definition of marriage, it was surprising to me how few constitutions try to define marriage. And most of the redefinition of marriage has happened at the interpretive level through the courts and not in constitutional texts. However, recent constitutional texts that have been redrafted have begun to engage in a changing of the definition of marriage that reflects the polarization that we have over this question, because you see it going in both directions. You see some states, in reaction to what they've seen in the world, trying to redefine marriage more explicitly as the union of one man and one woman. And other states, for example, some of the most recent constitutional changes in Latin America have tended in exactly the opposite direction, towards an explicit liberalization of that. So okay. What can we do to increase the recognition of the subjectivity? Marcelo, I'll just say, I don't think it's an accident. I didn't intend to do this, that all 3 of the examples of the cases in constitutional courts that I found most powerfully illustrative of this are in countries that are very traditionally Catholic countries. So I think that ethos does infuse the the language. To Vincenzo's point, I would only say that is exactly why I tried here and believe it's necessary to look not only at the question of rights, but at the question of subsidiarity. And it's in the union of a subsidiarity-oriented approach and a relational rights approach that you find the most complete recognition of the proper role of the family and its protection and its subsidium, not simply its autonomy, but also the proper support that needs to be provided. And finally, to Jeff, I have to say, a few words. This is, most deeply what I work on day in and day out, right? This was about constitutions, not about international human rights law, which is primarily what I work on. I love the Universal Declaration, and I am an advocate for returning to it as the original source of our thinking, in part because it is exactly the case that later treaties and even more later institutional interpretations of human rights with the international human rights sphere have ignored and abandoned the Universal Declaration's references to and importance of the family. It is something that we must return to and restore.
Please, Gregory,